Nasir Khan will talk you through the concept of construction dispute and how this is being settled through the mediation and negotiation processes. The construction industry is regarded as one of the most conflict and dispute-ridden industries, which has resulted in it being one of the most claim-oriented sectors. Traditionally, parties would enter into litigation, often a costly and long-winded means of resolving a dispute. Over the years, various methods of alternative dispute resolution, ADR, have been introduced into the construction industry as a means to avoid lengthy and expensive litigation. The possible ADR processes available to construction disputes are mediation, adjudication, arbitration, negotiation, expert determination, and court proceedings. Today, the center of our discussion will be the mediation and negotiation processes in settling the construction disputes by our honorable guest, Mr. Nasir Khan. Nasir Khan is a skilled and dynamic leader with just under 20 years of proven capacity to provide total solutions of estimating, procurement, commercial, dispute avoidance, management, and resolution through effective pre- and post-contract management. He is versatile and well-versed in successful delivery on major projects, including energy, utilities, commercial property, oil and gas, manufacturing, ports, highways, and rail infrastructure. Nasir has led large and complex claims on quantum, delay, and engineering issues. He is an engineer, chartered surveyor, chartered procurement director, and legally qualified. He has fellowship of various institutions and acts as a mediator, adjudicator, and arbitrator. Mr. Nasir Khan FCIB is currently associated as the infrastructure director of Curie and Brown. So, Mr. Nasir Khan, very much welcome to our today's program. Now the floor is yours.
Thank you very much. That was a very kind introduction. Very humbled to join all of you. Settlement is a very interesting subject, specifically when you deal with construction. So I'm going to try and flow some of the examples that I have encountered in the last 20 years dealing with claims and disputes and delivering projects. One of the last things that a funder or investor want to do is to have their project on hold, to fight claims, to have lengthy debates about who was responsible, who was culpable for, say, a delay, a defect, or any other costly variation that has incurred in the project. I'll take you through some of the examples today, and the purpose today very much is to understand what settlement is, why negotiate, why mediate? Why don't we just go to the courts and fight it into the courts? What is the barrier behind it? Just generally, ADR, the alternative dispute resolution, anything that is outside of the court's jurisdiction is alternative. The purpose that I live for, say, there are things that get you out of the bed. The thing that gets me out of the bed in the morning is to make dispute resolution like this to be the norm and make litigation in courts the alternative. Because we all know there are proven research around ADR. It's less costly, takes less amount of time, parties can still resolve it amicably. So why then go into the court when your project is halted, specifically in construction, which equates to over 15% of global GDP at the moment. The thing that gets us out of recessions is construction. The thing that keeps most amount of jobs in the supply chain is construction. So we need to take more proactive care for our profession and our industry. I'll talk a little bit about Curry and Brown, who I represent, bit on construction globally. The way I see disputes resolution and avoidance from my experience, I'll be sharing some examples today. Whether I like to negotiate or mediate, I think you will make that decision at the end of the presentation, why we should do negotiation or mediation and why we should go to the courts on arbitration or adjudication matters, etc. With some examples and some data from global research, I'll try and let you decide what is the best way of resolving construction disputes. So I'm not going to tell you about it. Through this talk, through this webinar, I want to give you enough tools and evidence so you make that decision that next time, if you face a dispute in construction, how you will deal with it. I think it's very important from that perspective that we understand it. And then in the end, of course, there are some issues that cannot be resolved without going through other formal dispute resolution procedures. So I will talk a little bit about that and we will summarize our talk. We've already spoken about May, so I'm going to move forward a little bit about Curry and Brown. So we are a physical asset management consultancy working globally, and we strive to add value to projects through our proactive approach to ensure that our clients obtain the best possible value for money. Not only when we start the project, but also take it through the life cycle of the project. So from procurement to completion, putting in the facilities into the whole life cycle perspective. What we do is very much from the perspective of advisory services. For today's topic, I'll just talk about our claims consultancy element and expert witness. We prepare, defend claims for time and expense on construction projects. Because of our expertise of delivering projects, it gives us that ability to be able to understand the intricacies of a construction project. We're also expert witnesses. So globally, we work with multinational in various different sectors to help with mediation, negotiation, because that's another element of mediation and negotiation, that you still can use your experts for that, because that provides you with the ability to negotiate, provides you with the evidence of your viewpoint, because it's all about the perspectives. And I will talk about it, why claims happen, and how we can adjudicate it better if we know the stand viewpoint of the other party. It's a similar thing. If you want to know how someone else is feeling, you have to put yourself in their shoes to understand that. What we do, continuing, we also do cost management and project management, so commercial advisory and project management services, which continues. Experience, as I mentioned, it's almost every sector globally, from commercial property to utilities, nuclear. I am actively working in the transport and infrastructure sectors at the moment, which kind of has become a little bit of my specialty to work in infrastructure. Locations, there is a global presence at the moment, almost in every country across the globe. However, limited presence in Africa. And there are specific reasons for that at the moment, why we don't work in Africa. But apart from that, the organization is present almost everywhere. So let's talk a little bit about our beloved construction industry. As I mentioned, about 10 to 15% of GDP is supported by construction. Now, this equates to trillions of dollars or pounds, millions of jobs globally. It is a significant contributor to the global economy. So amongst procedural complexities, where risk management method statements, I'll talk a bit about deliverables. You have numerous documents to go through, numerous design, numerous ground investigation complexities, unforeseen circumstances, weather, wind, storms. I believe in Bangladesh at the moment there are high winds and storms going on. So how can you operate a crane during that time? So construction generally involves unprecedented situation. Who had imagined, say last year, or even in December of last year, January of this year, that our construction sites will have a closure because of COVID-19? We did not anticipate that. We had no inclination of that. So these are some of the procedural complexities that are unavoidable, they are unavoidable to complete a project, and then it sometimes in construction is known that it is almost impossible to complete a major construction project without disputes. Now, the question that comes in is, what are disputes? What is a dispute? Because if I say I'm right, it shouldn't be a dispute. But because you do not agree with me, it becomes a dispute. So it becomes a misunderstanding between two or more parties. And that's kind of the Oxford Dictionary definition. Now, what we have to understand is that disputes in the construction industry continue to proliferate, and mainly through various reasons. One of the key issues that I have encountered, and I will show you some evidence through global surveys around disputes and claims, is the contracts don't actually say what we want to do. There are no written procedures of change control. A dispute becomes a dispute when we don't agree with it. Otherwise, construction contracts don't end, or probably don't go to the next day without an agreed variation. So, for example, as you see from this beloved photo, is it too late to add 4 floors? Now, if both parties agree with it, that no, it's not too late, we can add 4, 6, 8 floors, how many floors you want. Great, there is no dispute. But if then the engineer says, sorry, the foundations will not be able to take that load, or we did not calculate for that, or we did not take planning permission, if the regulations apply, then we have a problem because both parties don't agree with each other's position. So these elements have to be understood from that perspective. We could have differing site conditions, design errors or changes, interpretation differences. People may want to ask to accelerate the work. So, for example, there's a big hospital opening. Due to COVID-19, we had so many hospitals that were due to complete, say, end of December 2020, but we had to accelerate the works. People were working in 3 shifts with social distancing and every other protocol involved, just to finish them early because we did not know what capacity may be needed. And I'm talking about the UK. Construction failures, again, I'll talk a little bit about what is kind of the panacea of having all these different disputes from that perspective. So apologies, I forgot to push the slide forward and just continue to talk about it. So these 5 causes of disputes that you see are from a global survey of construction disputes undertaken by Arcadis. Just Google it, they publish it every year. And what you will be able to see is for each region, how each region differentiate from each other in that perspective. So for example, if I talk about the UK, this cause as failure to make interim awards or extension of time, the granting of that, this is the #1 cause of disputes in the UK. Time delay, extension of time are the biggest cause of dispute in the UK. When you say America, or North America, I should say, rather than South, the failing or the understanding of each other's obligations is the biggest cause of dispute. So nobody knows how to apply for change control. Nobody knows how to put their notifications. Well, people do know, but some people don't know. That's why these disputes are caused. Then when you look at continental Europe, their biggest cause of dispute is errors or omissions in the contract documents. Now, errors or omissions in the contract documents means you either did not provide all of the design detail, ground investigation reports were not there. I'm currently dealing with some disputes where asbestos has been found on site, but in the original contract documents, there was not even a single mention of asbestos. Now, people from the construction industry or who have come across this, there are specific legislations in the UK and around the world for asbestos because it is lethal and can cause significant amount of damage. So how do you deal with such errors and omissions? And it's one of those things where I'm representing the defendant, but I'm saying to them at the moment, you don't actually have a case. And we have to be, as the expert, have to be open about it to try and bring people into a common ground. Because what's the point of defending something which is not defendable? So these are some important aspects. And if I say about disputes in the Middle East, because Middle East has a huge contribution to the construction sector, mainly, if you look at it, it's poorly drafted or incomplete and unsubstantiated claims. So they are asking for a claim for increased cost or extension of time, but they cannot substantiate it. So which is why it is one of the biggest reasons out of all of the global disputes around the world. To show you a bit more context around it, this is the Global Construction Disputes Report. One good thing that came out of it is that the average value of disputes and the length of resolution has decreased slightly from previous years. One of the biggest causes or areas of these disputes are generally buildings, education, healthcare, retail, kind of commercial type element. They see most disputes, which kind of makes sense as well because they are more complex. There is more M&E element, other elements involved. So we need to think about it from that perspective and probably take more attention to it. Infrastructure projects generally very large, and just like health and safety initiatives, you put in more controls to try and avoid such disputes. Now, another thing that I always talk about is perception, which is very interesting because the scale, cost, and complexity of many construction projects and the number of parties involved mean that disputes often arise. We've discussed that. Construction disputes are often of a technical and or complex nature, involving a large number of documents and with expert evidence playing a central role. Often experts of multiple disciplines are required. So for example, an expert in the defendant's particular field, maybe civil engineering, mechanical or electrical, a delay expert, a quantum expert. So time, money, defects are the most common types of defects if you look at it. When you talk about time, is the contractor entitled to one? If so, how long? Is it prolongation? Is it extension of time? Is it some other cause that has been the relevant aspect to it, whether liquidated damages apply or not? When it comes to money claims, it could be late payment, it could be interim payments, could be additional payment, increase in contract price due to design change, due to unforeseen circumstances in the ground, due to various other things. Why are we not talking about it? Why are these even disputes? One just, people looking outside of the construction industry just say, why don't you just apply common sense? If something is written in the document, great. If it's not written, just pay for it. But then this is where the gray area comes in. Oh, interpretation, should have assumed, should have made assumptions, should have priced for it. Whose risk is it? Contractor risk or the client risk? So money also then becomes a big part of disputes. And then when we talk about defects, is it design defect or workmanship defect? So there's an awful amount of case law around it just to distinguish what type of dispute it is, what type of defect it is. Latent, patent defects, then you're looking at limitations and exclusions. Is it something being built on firm ground, soft ground, design considerations not taken on board? 3 years ago, I was working on a project in central London, and in the contract documents, there was no mention of ordnance to be found. So they were digging and they found some old, dilapidated, well, old, of course, Second World War bombs buried in the ground. So whose risk is that? Because now you need to bring in the ordnance team, and then the squad comes in and removes those carefully while that bomb is being taken out of the site. The whole construction site is stopped. So you've got people, plant, everything sitting. Whose risk is that? So why don't we talk about it and try and mitigate our losses, negotiate it, and then see who's best placed to do that. So let's talk about how to avoid construction disputes, because this is an important area I always look at, because these kind of four areas lead us to whether we should negotiate or mediate. If you look at the three-legged stool, it's built up of technical, behavior, commercial, and that's what makes collaboration successful. If our design team is collaborating, but our commercial behaviors are not good and we are confrontational and we are not certifying the applied amount, I'm going to talk the quantity surveying language, apologies for that, then the project is not fruitful. People will not be happy, because why do we work on a construction project? The contractors works because they want to get paid. The client is making the contractor work because they want a product, say a commercial building, a bridge, a road, a port, a marine infrastructure. It could be anything. So these are four areas that I work with on when we are starting large infrastructure projects. We look at pre-contract preparation very carefully because it protects us against future conflict. It gives us a structured approach because well-drafted contracts are easy to understand. They include practical systems for avoiding and resolving disputes at an early stage. They help to develop a culture of collaboration between the parties. They provide us with the means that our conflicts are amicably resolved as a variation in the project rather than it becoming a dispute. So it gives us a structured approach to negotiate our problems. Now, when we are identifying and dealing with emerging disputes is when we can do early intervention, because construction, it's one of those pieces that disputes cannot always be avoided. And when differences emerge, it is sensible to use procedures which facilitate an early review and disposal of the disputed issues. So early intervention techniques are effective at preventing disagreements from becoming full-blown disputes. And this is where I see negotiation as an early intervention. Amicable resolution, if you can't resolve it yourself, what you are now dealing with is you are asking a mediative procedure to help out, because it will enable you to achieve a settlement without going eyeball to eyeball, confrontation procedures such as arbitration or a court action. So mediation is then the next step. So we're looking at a tiered approach towards avoiding or resolving disputes. And then when everything ends, you've got no other option, you appoint an arbitrator and an adjudicator who resolves your dispute. In all of this, one thing we need to think about is, where are the courts and the rule of law and everything that we talk about? So why are we resolving disputes? I mean, again, going back to first principles, the rule of law is the basis of order and just conduct in our society. And everything through all these procedures, what we are trying to do is bring order and just conduct. And if we are not bringing order and just conduct in the society, we're not working with fairness and transparency. So I understand Bangladesh is not the only country which is overflown with litigation delays. UK is the same. I did some research last year on pending court cases in the UK. On some cases, we get dates for 2 years, So you have to wait for your case to be heard for 2 years before you've got any chance. So if it's construction, okay, TCC, technology and construction code, things are a bit different, but you're still waiting 6 to 8 months. So if you are in the middle of a construction project and you have a dispute, do you really want to wait 6 to 8 months, or would you try and resolve it either amicably through an early intervention or through your own dispute resolution procedures? So this is where the principle comes in, why alternative dispute resolution is so prominent and why it has taken such a huge space in our world of construction dispute resolution. Forms of dispute resolution. So just want to talk about a little bit here, because this is an area which I try and deal with in a bit more detail, because the ADR continuum is very important. And next slide, I'll be talking a little bit more about it in detail, because about is what type of ADR do we need? What type of dispute resolution do we want? Do we want the control as the parties? Then it's very much informal dispute resolution, consensual. Both parties are still having tea together, they're still having lunch together, they may still have dinner together. And it's not one of those when you look at the party who's, say, a claimant or a defendant, and you look the other way because I don't want to talk to them. So divide this right bang in the middle, I would say, even with early neutral evaluation, and you're still friends with the other party. Okay, you don't need to be friends with them, but still, if you've got a collaborative approach, if you want to get things built and seen built together, then you've got to think of it from that perspective. So that's one aspect. The formal approach then becomes your arbitration, adjudication, litigation. Now, adjudication in the UK is quite prominent. It's being done in Singapore, it's been done in Australia, Ireland, started in South Africa as well, which is one of the most used dispute resolution in the UK. Not mediation, not negotiation. Again, another reason for that is negotiation and mediation sometimes is not recorded in the same way, specifically negotiation. But generally, across the globe, the most used system for dispute resolution is negotiation, and I'll talk about it from the context of the global evidence that we have. Okay. So things to consider when you are considering what form of dispute resolution do I want to achieve. So this is where I gave the previous slide example as well, whether you want the control or you want the person who is deciding your dispute to have the control. Now, one thing you need to remember, why settlement through negotiation and mediation is so important in construction dispute and is so successful, is to have control. In litigation and arbitration, you give away your control. The value of the dispute. Now, if it's a smaller dispute, you really don't want to go to lengthy arbitration or adjudication processes. You'll try and resolve it amicably amongst yourself. A high value dispute can justify a more costly ADR process. But if it's a low to medium value dispute, people would just avoid it from that perspective. Now, another thing so this is kind of my checklist on to consider for your disputes. The importance of the dispute to one or both of the parties, because a party may consider it crucial that a case stays out of the public arena or the court. So confidentiality becomes a prominent cause why you would like to resolve your issue through negotiation, or if negotiation fails, through mediation. But you need to consider the importance, or say intractable appropriate settlement avenues in that as well, because you don't want to give away your, say, weakness that I don't want to go into the public domain, because the other party could use that against you. Number of parties involved. Now, if there are multiple parties, mediation may prove difficult, because I've seen it from my experience. Mediation between, say, up to 3 parties is okay. When it's more than 3 parties, even with 3 parties, it becomes a bit difficult. I would say keep it to 2 parties, or a hybrid or 2-stage process, such as MEDAB. So which is kind of, you start with a mediation. If mediation fails, you go into arbitration. But again, things are still say without prejudice, so you can still use those elements into that. Okay, then the other element we look at, complexity of technical or legal issues. Now, it will sometime be important. There is a very important, say, nuclear engineering dispute issue. How can you go to a court to decide your nuclear engineering issue when the court does not have the expertise to resolve it? It will just look at the party's submission and won't be able to do any analysis. So that's another reason why ADR is so successful, because it's not only done by lawyers, it's done by engineers. If it's a financial institution dispute, it's done by accountants. If it's a medical negligence dispute, it's done by surgeons or doctors, who do take some legal appreciation. They don't have to be fully legal qualified, but this is where ADR becomes important. And this is where mediation and negotiation would be successful, because you are the masters of your own destiny. You know it for well why an engineering defect or a delay effect or anything else has happened on your projects. So negotiation and mediation works better. Same with issues involved timing. Again, if you have got tight time scales for resolving your dispute, you're definitely not going to the court. You're definitely not even going for adjudication, or even arbitration becomes such lengthy process. And you've got to decide things quickly. You'll go for negotiation or mediation. Cost and financial position of the parties. Again, various ADR process. Sometimes people say that arbitration is just another layer of court procedure. Unfortunately, I understand this a little bit from the South Asian countries, who inherited the British 1940 Arbitration Act, and then took almost 50-60 years to substantively change it or update it. It becomes difficult. So that's another issue why arbitration sometimes becomes very expensive, if not as expensive as litigation, because if we are not familiar with the process, we may as well just do a full trial. So that's an important aspect to think about. Relationship with the parties. Now that's very important to me, because in a public sector capacity, if you're delivering to, say, the government or the public sector, you sometimes fall into that trap. My relationship will be over if I take them to a dispute resolution procedure. So that's why, if you want to sustain your relationship, negotiation and mediation works far better, because the informal dispute resolution techniques help with that element extensively. I'll take you through the most popular methods for resolving disputes globally at the moment. And what you will see is, this is the global ranking of dispute resolution in the world, around the world, being taken on. A dispute has occurred, and why are parties dealing with it this way? So party-to-party negotiation is the most popular method of resolving a construction dispute, then mediation, and then arbitration. Courts are way down below. So people in construction disputes generally try and use ADR as a perspective, from that perspective. Now, most important factors in the mitigation and early resolution of disputes, again, comes back to the point that willingness to compromise. okay, don't want to subjugate or put a relationship into jeopardy. So you want to, you've got that desire to continue the relationship. When things go wrong, it comes in our nature to sometimes compromise. Very few people decide a confrontational approach and say, I'm going to fight it to the end. I know a few people who are like that, unfortunately. Um, Accurate and timely schedules and reviews by project staff or third parties. So that's an important stuff. This is where I said sometimes if you are unable to decide something yourself, it's always good to ask an outside third party. This is a problem. Can you please give us an independent view on it? And then when that independent view comes in, I didn't think of it that way. Or yes, there is some substance or weight in the other party's submission. So I act as expert quite a lot, where two parties who have absolutely no idea what they're about, they have a dispute. I'll just advise one party independently or sometimes jointly for both parties, in terms of if both parties agree on appointing. So I look at the dispute, look at the submission. So this is not adjudication. This is kind of an expert appointment to look at the view independently. It's not final determination. It's interim and it's a recommendation only. Contractor transparency of cost data in support of claim damage. One thing I've learned in my claims and dispute resolution scenario is the impact of CEES. C is basically what you've got to think about it from the perspective is that something has happened, a claim, something has happened that has triggered an event. So for example, causation is COVID-19 event. It's caused delay on site closures. Entitlement, what does the contract say about it? Is it force majeure? Is it frustration? Or is it change of law in some countries where the law basically said, stop all works out on site, everything in lockdown? So entitlement comes from the contract, and then you look at substantiation. And most contractors, when they are claiming, they fail on substantiation because they don't have good records. So if you've got your documentation and good records in place, then you will be able to substantiate your claim, and there will be no debate about it, because it's not about my view against your view. Everything is on record, on paper. So I'm currently dealing with a claim on weather, for example. There was one of the heaviest rainfall Britain has seen in February of this year over the last 10 years. So we had 3 storms, there was lots of rain, there was lots of hurricanes and winds. What meant was you couldn't do any crane operations. Work on site was suspended because it was that bad. And you allow for some rain, but not that much. So the question that comes back in is, what evidence can the contractor give? So the contractor gave evidence, timesheets, all the labor, all the staff, all the plant that was idle on site, and it became an easier calculation to accept their claim. So that's another, that's one of the important factor, that if the contractor transparently provides their cost data, then you will have early settlement, because the whole idea is not to take the dispute into a formal dispute resolution process, try and settle it. Most effective claims avoidance techniques, I'll talk a little bit more about it. On global scale, you're looking at risk management. Now, we choose our contracts as risk management because the contracts are our risk mitigation procedure. Contract and specification reviews. If you want independent third party to have your contract and specification review, great. If your internal teams are capable of doing that, ask them to do it again, please, because a lot of things are missed. And this is something that I find on a regular occurrence. But we thought we asked the contractor to deliver it. Yeah, but the contract document doesn't say that the contractor has to deliver it. That becomes another issue of claim. And then when you view it, you are able to resolve it because the client sometimes I've seen, again, I can only talk about my personal experience, that but we thought they were supposed to provide it. Okay, how? If the contract document doesn't say that, it becomes a bit difficult for us to prove it. Third party schedule reviews, etc. So we need to think about it from that perspective. Now, how to negotiate is key. Now, you don't just enter into negotiation blindly, and this is my suggestion to all of you from that perspective. When I'm dealing with negotiations, acting on the project as commercial director or going in as independently to try and help with the negotiation process between the parties, what we are trying to do here is, you need to think of it as negotiations happen often between the parties. We negotiate at home with our children when they want something. We negotiate, no, you can't have as many sweets as you want. We negotiate with our wives, with our parents, with our work colleagues. We negotiate on our commissions, on our contract rights. Everything starts and ends with negotiation, and it's kind of human life. And as Mandela said, it's our greatest weapon. And people who are good at negotiation get the most out of an issue because they are able to convince the other parties of their standpoint and their viewpoint. Because the whole perspective of negotiation is you want to bring people to a common ground. So 4 basic principles of negotiation. So these are the steps that I usually take. 4 basic principles. I try and be hard on the problem and soft on the person. So rather than being confrontational or heavy hitting, argumentative, because that's the end of negotiation. If you are being argumentative, if you are raising your voice, if you are engaging people with anger, even at home, there is lots of negotiation techniques. You can see lots of videos and read literature about it. Focus on the end result and the need rather than your own position. It's very important to reframe the situation and the need, that if we succeed in resolving this problem, what differences would happen. Say if you're dealing with your construction project and you have a disagreement on providing something different. Say it was a window structure or anything on a building project, and you are having this issue. Just have your discussion. When we finish it, how the aesthetics would look, how the cost would look, everything else. Try and reframe it. Request checking of understanding of each other. Be inventive about the win-win position, because the whole perspective of negotiation is it's a win-win. Although some people look at it negatively and basically say there is no winner in a negotiation and both parties are a loser, I am a bit more positive from the perspective. I see both parties as the winners rather than the losers. So we need to think of it from that perspective. We need to make clear agreements of what we are trying to achieve, because when you're negotiating contract claims, you have to understand the perspective, what you are trying to achieve. Try and look at your end goal from that perspective. Do you want to settle, move on, deliver the project effectively within the time frame or a different time frame with minimization of cost, best value, or do you want to go into confrontation and not deliver the project? I think the answer comes in automatically, that you want amicable resolution and settlement of so that's why it becomes important. When you are negotiating, do your homework. Don't just jump in and shoot from the hip. Don't do that. It's important to understand your claim, your contract documents. In construction, I've gone into some discussions where the other parties have turned up really skillfully with a strategy of hitting points and ask the questions accordingly. And if you are not well prepared, you may not be able to defend it at that point, because that's what construction requires, so much arrangement and interesting documentation control from that perspective. Verbal communication is important in negotiation because you have to make sure that you are listening to the other party and then communicating. And non-verbal communication is also important. So I've been in negotiation where it's about 6 or 7 of us on this side of the table, 6 or 7 on the other side of the table. And every time, say, a question is asked, the other party always looks at their own person to see what is he about to answer. Is he looking down on their notes? Is he scratching their head? Is he looking nervous? So non-verbal communication is also important, and it becomes part of your negotiating strategy. So I've always say that you need to think about it from that perspective. And I always look at asking a question, looking at every single one. With COVID-19, online work has become very interesting for me, because now I'm looking at every single photo. Say, you can do Microsoft Teams or Zoom gallery view. So instead of just looking at one person in the claims meeting, negotiation, whatever is happening, I can look at every single one's face. I can see what they are thinking after each question. Whereas in a physical meeting, you have to turn your neck either side to see what the other party is thinking. So I think that's really, really important. And I can't say that working remotely is a blessing from that perspective, but what it has done is it's given that perspective that we can relate to it in that way. And when you've done your negotiation, do formal deed, contract variation, or agreement signed by both parties, because a negotiation is non-binding until it has been signed up in a piece of paper, written or otherwise, by both parties. So that's an important aspect, and people sometimes forget about doing that. And I always remind that your negotiation, whatever you discussed at that point, you can't go back on it, because sometimes in large corporate organizations, when parties are negotiating, they have to then go to their reflective boards to seek agreement, that, okay, this is what we've negotiated, and now we need approval. And if the approval is not given, that negotiation is failed. So go in with the authority that you have the authority to negotiate. Let's talk about mediation. So that photo, all of the photos that you see here, they were all taken by myself, because when I'm visiting sites, it's just a habit. I take photos myself for my own personal collection, because I don't just try and sit in the office. If I'm dealing with a dispute, I try and get into the grains of it, what's being on site, what is being discussed, what the issues are, understand people, their behaviors, because that also becomes a key important part of dispute resolution. Because if you see there are people who are very confrontational, who actually don't want to work collaboratively, then that's your first step. Make people work collaboratively, and then hopefully your disputes will disappear. When we're talking about mediation, I think most of you are very all familiar with that. It's the consensual process where you bring in a mediator to assist you to try and settle your disputes amicably. Now, a question that has been asked in the UK quite a lot is it voluntary or is it compulsory? Because the civil procedure rules that we have here require us to go and mediate, but they stop shy of making it compulsory. So it's asking us to mediate, but it's not mandating it from that perspective. So it is a voluntary process. Parties are not obliged to settle their case at the mediation if they do not feel persuaded by the other party. Mediation has to have some time limit. You can't just continue for mediation for 3 months if both parties are just not moving. because that is then a difficult position to have, because you are not moving each other's position. So don't do waste of time, because that's another thing. I mean, I read a King's College survey. 25% of people said mediation was a waste of time. Now 75% said it was really good. So that's a positive note, because if 75% are still able to resolve their disputes through that, then that's amazing, because it's a success from that perspective. Um, because even if mediation done is during that time period, it has narrowed the dispute. And if your dispute is narrowed, then you are in a better position to be able to resolve it in the court. So that's another reason why I always say that we should aim for negotiation, after that mediation. And if mediation then fails, then what next? Before I go on to that, just few things I want to talk about is the UK courts provide significant assistance to parties who try and settle their claims in mediation. I mentioned pre-action protocol. There is great guides and books written in the UK around mediation, the steps, the protocols. And again, mediation understanding should not just be for the lawyers or people who are mediating. I think what our responsibility is to tell the business users, the general public, the engineers, the technicians, the commercial people, the benefits of it. Because if we don't educate people about the benefits of settlement through negotiation and mediation, they know only one thing: go to the court. So that's an important aspect. We also need to think about what's the best way, or what is the best time to go into mediation. Is it when both parties are really knucklehead with each other? No, that's not the best time. I think the mediation works best when it's done amicably, and you still are content and you want to continue with your relationship. So that's always successful from that perspective. Um, if your neutral evaluation is required, so if negotiation and mediation is failed and you want to appoint a third party, you can either appoint an expert or you can appoint somebody who can help you with early neutral evaluation. So which is, a third party. It could often be a lawyer or an expert trying helping you with assisting with the dispute. So I write expert reports regularly on claims. Again, as I said, they may or may not be binding. So generally, the ones I do are not binding, but it helps the parties to understand their claim. So this is another view of how you can try and settle your disputes. A thing that we do now quite a lot, and people who are operating on the FIDIC contracts understand from clause 20 the requirements of dispute boards, dispute avoidance panels, adjudication board, whatever you want to call it. There are other forms of contracts as well that look into this aspect, because a dispute board, again, is a job site independent and impartial dispute resolution facility, that if you've got senior or say experienced people coming on your project every quarter, looking at how the project is working, they meet the team members, understand their behavior, understand their complexities, provide their expertise. That helps in avoiding disputes. So a number of large infrastructure projects, and this is another reason why large infrastructure projects see less disputes, is because most of them appoint dispute boards, which help avoidance and early resolution of disputes. Summary time. Going back to the position why are disputes happening? Is it contract documents? Is it unsubstantiated claims? It could be time, cost, or money. I think it's and health and safety as well, because we need to think about health and safety. These key ingredients of the construction project, but these are also the key ingredients that cause and often result in disputes. So we need to think of it, how to make sure that they are worked in a way that we don't have to go into dispute resolution in that aspect. Um, it's a situation where we need to think of it, in a way that if we are trying to settle amicably, we are continuing with our relationship. And as humans, as people, it's in our general interest, because we are social animals, and COVID-19 has kind of said we have to live in isolation, and people are urging to go out, to meet each other. And that's another thing. We don't really want people to be our enemies or to have anger with us. So if we can resolve our claims or disputes amicably, where we can still work on another project successfully, why not? So it's kind of, proven from that aspect as well, that if we have to overcome our problems and understand the situation, we have to deal with it that way. There is always a willingness to compromise amongst the parties, and that aids the early resolution of disputes. I hope what I've told you today, with few of the examples that I've given, and some of the descriptors through the global surveys on dispute resolutions, may help you to understand that having a fair and reasonable approach towards dispute resolution, where we can put ourselves in the shoes of the other party, helps. And in my view, the construction industry certainly encourages it, because collaboration is key in today's day and age. And to overcome the problems with litigation and other elements, I think it's important that we sign up a kind of conflict avoidance pledge, because if we are working on it together collaboratively, it has to work together, because a single party not working collaboratively does not help us resolve or settle our dispute. And this is a great statement or advice by Frankie Sanders, where there is a difference between coercion into mediation and coercion in mediation, that you can't force people to mediate or to settle. It has to be built into their own nature, that they want to settle, and they want to do it that way. Thank you very much.
Mr. Nasir Khan, thank you very much for your knowledgeable insights on our today's topic. I have some questions for you. May I ask them?
Yes, please.
Yes, sir. Okay, so one of my question is that do you think that behavioral change is a better way to improve construction hazard and safety performance than suing?
Goes without saying, everything starts with behavioral change. And an organization I worked for in the past, and their mantra on safety performance was that sometimes people think that if we are increasing quality, we may slow the project down. But actually, when you increase quality, you improve safety as well as improve the product speed. Behavioral training is important, and that's why we sometimes take a very technical approach towards trying to solve problems. And I think there has to be an element of art in it as well, because relationship management is a combination of science and art. You can have your key performance indicators. You may measure, performance of people, business targets, budgets. But if you're not observing the behaviors of people, the what makes them work well. Are they happy? Are they stressed? Are they performing well? So those elements also help. So on some of our projects, we always go out with the team and take them out for dinner at least once a month. We do some socializing together because we have to know people at an interpersonal level as well, and that's very important to improve collaboration and safety, because it's like you have to keep yourself safe but everyone else safer, and the only way to do that is by knowing people and approaching it collaboratively.
Thank you very much, sir. I would like to know right now that how can we possibly reduce the incidence of claims and disputes in construction contracts? What are your suggestions for the people, employers, and employees?
So there are various ways that we can do that, and one of the ways that I look at is understanding the clarity and objectives of both parties. I think if people understand that, they will work better on trying to observe it. The Royal Institute of Chartered Surveyors published their dispute avoidance toolkit back in 2018. If people are member of the RICS, they don't have to be member. You can still download the dispute avoidance toolkit. It gives you some step-by-step approaches on construction, large construction projects, or even small construction projects, how you can work collaboratively with each other. My personal interaction and approach on it is having clear objectives, understanding each other's wants and needs, and being open and honest. I think where you have integrity of your behaviors, it works very successfully, because if something's gone wrong, talk about it, work together to find the solution rather than try and hide it. Because the more we are open and honest and true and transparent about our behaviors and about our actions, the less confrontational approach becomes.
Sir, you can continue.
That was it. I hope I answered the question.
Thank you very much, sir. So I guess people may be asking something. I'll let you know when we get any questions from our audiences. I want to proceed with another question. I hope you don't mind answering it.
No,
I want to
please.
know what type of procurement strategies to be followed for constructing Sky Resort and Rehabilitation Center. Do you think it falls within our today's topic, or any kind of dispute arises while the strategy that is suggested and the strategy that has been followed has a huge difference between them? So what can be done in such a case?
So I talk a lot about procurement. I teach procurement at the university as well. So it's kind of my favorite subject. If you go back on one of the slides, I talked about how to avoid construction disputes. The aspect I talked about pre-contract preparation. When you look at time, cost, and quality, time, cost, and quality become our key subjects for everything around a construction project. What type of procurement approach we want. Now, in terms of quality, if you talk about high-rise building, do you want to select an architect who will do the architect concept design? Then you want to select a cost consultant who will do the quantum and the cost analysis of it. And then you go out to a designer who will design that building. And then you go out to a builder who will construct it. Or you want to go to a turnkey provider and say, I want a high-rise tower. So all these different questions become a critical part of your procurement strategy. Once you've started honing it down, so it's a step-by-step approach. So there isn't a straight answer for that. So unfortunately, I have to give you the overall perspective on it. So it's a step-by-step approach. Once you've decided on what approach you want, so you want a traditional procurement method, or you want to go for a design and build, or you could go for a collaborative approach, or you could go a turnkey EPC type scenario. You choose that. Then you choose your contract to suggest what will work. Because say in FIDIC, the silver book, the red book, the yellow book, they're all different. NEC, you can go for an option A, option B. All these are different standard form of contracts to support your procurement strategy because they allocate risk accordingly. So if you're going for a high rise, it really depends on what stage of the project you are, whether you are at initial concept stage, or you've already got the design and you've got the bill of quantities, and all you want is to select a builder. Then just build only procurement method. So your procurement strategy again goes back to time, cost, quality. Your claims go back to time, cost, quality. So everything revolves around of time, cost, and quality.
Thank you, sir. Thank you very much. I guess that's all for today. I've already asked the questions that I've received and also the questions that I had. Thank you very much, sir, for your delightful insights. And I guess we have to finish right now. So you're very much welcome. And thank you for giving your valuable time with us. We hope to meet with you soon again.
Thank you. Thank you very much for having me.